For millions of immigrants, obtaining a U.S. green card, which grants lawful permanent residency, is a life-changing goal. A green card offers more than the ability to live and work in the U.S. indefinitely. It's also a critical step toward citizenship. Fortunately, the U.S. offers multiple legal pathways to permanent residency, each with its own eligibility requirements, processes, and timelines. Whether based on family ties, employment, humanitarian relief, or special programs, understanding your options is key to choosing the best path forward. In this video, we'll explore the top 10 legal pathways to permanent residency in the U.S., offering a clear breakdown of each route, who qualifies, and what to expect. 1. Family-based immigration. One of the most common paths to a green card is through family sponsorship. U.S. citizens can petition for their spouses, parents, children, and siblings, while lawful permanent residents can petition for their spouses and unmarried children. Immediate relatives of U.S. citizens, spouse, unmarried children under 21, and parents, face no visa caps, which speeds up processing. Other family categories fall under the preference system and often involve longer wait times due to annual visa limits. Proving the legitimacy of the relationship is essential, particularly in marriage-based cases, which are closely scrutinized by USCIS. 2. Employment-based immigration. Another prominent route to permanent residency is through employment. Employment-based, EB, green cards are divided into 5 preference categories, EB-1 through EB-5. EB-1 visas are for individuals with extraordinary abilities, outstanding professors, or executives. EB-2 and EB-3 are for professionals with advanced degrees, skilled workers, or individuals with exceptional ability. Many of these categories require labor certification from the U.S. Department of Labor to ensure no qualified U.S. worker is being displaced. These petitions are often employer-sponsored, although some, such as the National Interest Waiver under EB-2, may be self-petitioned. 3. Diversity Visa Lottery Program. Each year, the U.S. government allocates 55,000 green cards through the Diversity Visa (DV) lottery program. This program is open to individuals from countries with historically low rates of immigration to the U.S. Applicants must meet basic education or work experience criteria and apply through an annual lottery system. While it's a low-cost way to apply for a green card, it's also highly competitive and based entirely on random selection. Winners must pass a consular interview and meet all admissibility requirements. 4. Refugee or asylee adjustment. Individuals who are granted asylum or admitted to the U.S. as refugees can apply for a green card after 1 year of residence. Refugees are automatically eligible to apply for a green card after 12 months in the U.S. Asylees also become eligible after 1 year but must file Form I-485 and meet additional requirements, such as continuous presence in the U.S. and not resettling in another country. This pathway is essential for individuals fleeing persecution based on race, religion, nationality, political opinion, or membership in a particular social group. 5. Special immigrant categories. Special immigrant categories offer unique paths to permanent residency for individuals in specific roles or circumstances. This includes religious workers, Afghan or Iraqi nationals who worked with the U.S. government, international organization employees, and certain juveniles who have been abused or neglected. Special Immigrant Juvenile Status, SIJS. Each of these subcategories has specific documentation and procedural requirements. For example, religious workers must demonstrate at least 2 years of continuous service in a qualifying role with a U.S. religious organization. 6. Investment-based immigration, EB-5. Foreign nationals who invest a substantial amount of capital into a U.S. commercial enterprise may qualify for a green card under the EB-5 Immigrant Investor Program. To qualify, the individual must invest $1.05 million, or $800,000 in targeted employment areas, and create at least 10 full-time jobs for U.S. workers. This path is attractive for wealthy investors and entrepreneurs, but it involves complex financial documentation, potential project risks, and a 2-year conditional residency period before receiving a permanent green card. 7. U-Visa for victims of crimes. The U-Visa provides immigration relief to victims of serious crimes, such as domestic violence, human trafficking, or sexual assault, who have cooperated with law enforcement in the investigation or prosecution of the crime. After holding U non-immigrant status for 3 years, individuals can apply for a green card. This humanitarian path is crucial for helping victims escape abuse and rebuild their lives. The U-Visa program is subject to an annual cap, which can cause delays, but it offers a valuable route to lawful status and protection from deportation. 8. T-Visa for human trafficking victims. The T-Visa is reserved for victims of severe forms of human trafficking who are physically present in the U.S. on account of such trafficking and who assist in the investigation or prosecution of the trafficking crime. After 3 years of T non-immigrant status, or once the investigation is complete, the individual may apply for a green card. Like the U-Visa, this path prioritizes safety and cooperation with authorities, recognizing the vulnerabilities and hardships trafficking victims face. 9. Registry for long-term residents. The registry provision is a lesser-known path that allows certain long-term undocumented immigrants to apply for a green card if they have resided continuously in the U.S. since before a specific cutoff date, currently January 1, 1972. While very few people qualify under the current date, proposed legislation may update this eligibility window. Applicants must prove good moral character, no serious criminal record, and continuous residence in the U.S. for the required period. Although rare, this pathway is a legal option for those who have lived in the U.S. for decades. 10. VAWA Self-Petitions, Violence Against Women Act. Under the Violence Against Women Act, VAWA, certain battered spouses, children, and parents of U.S. citizens or lawful permanent residents may self-petition for a green card without the abuser's knowledge or consent. This provides a critical safety net for immigrants experiencing domestic violence or abuse, allowing them to escape dangerous environments without jeopardizing their legal status. VAWA petitions are confidential and do not require the abuser's involvement. Once approved, VAWA beneficiaries can apply for permanent residency through Form I-485. The U.S. immigration system offers diverse legal pathways to permanent residency, each suited to different personal, professional, or humanitarian situations. From family reunification and employment-based opportunities to protection for vulnerable individuals, there is no single, best route, only the best route for your specific case. Navigating these options often requires careful planning, precise documentation, and, in many cases, legal guidance to avoid delays or denials. If permanent residency is your goal, understanding these pathways is the first step. With persistence, compliance, and the right support, obtaining a green card can become an achievable milestone on your journey to building a life in the United States.